Ready whenever you are, Andreina.
All right, good morning, everybody. Welcome to our Thursdays Very Weekly Mastermind. We haven't missed a beat, even though we're from home, or in Claudia's case, she's still in the office today. But I think that the world that we're living in right now is going to take us into probate cases because a lot of people are going to have unexpected deaths of loved ones, right? And I think that we're going to enter a probate world more so than we've seen in a little while. So and I know probate is something you guys have been asking me for, and everybody kind of wanted to do something with the whole probate and the process and kind of know the process of. So I think tying it into what we're living today, I think it was perfect, I guess you can say. So I want to introduce everybody to Claudia Cobreiro. She is an attorney. She's a real estate attorney. She is part of our group chat, and she's going to lead the way on this mastermind. Again, everybody else is muted, but if you have a question or if you need her to slow down for any reason, please unmute yourselves and let her know. It's not as open forum as normally because she's going to lead the way, but I do want everybody's engagement and chiming in into this mastermind today. Claudia, this is all yours.
Good morning, everyone. Like Andreina said, my name is Claudia Cobreiro. I am an attorney. I practice real estate, family law, business law, and we do probates in my office as well. We've been talking in the real estate chat about doing this class for a little while, so I'm glad we were finally able to put it together. Independent of what's going on right now, right? Things are a little crazier than usual in the world. But we are in a time where a lot of the baby boomers are older. It's a generation or a segment of the population that makes up a big chunk of our population right now. And the circle of life is that unfortunately, they're going to pass. And a lot of times people pass and they do not have the proper estate planning in place to avoid having to go to probate. Now, I'm sure that you guys are all familiar with probate and what it means, but I'm going to break this down from step one for everyone so that to make sure we're all on the same page. Like Andreina said, if you have any questions, please unmute yourself and ask the question so that we can clarify as we go on in the event that anything that I explain is not clear. But I am going to try to leave a small amount of time at the end of the meeting to account for any questions that you may have after I finish the presentations for something either that I didn't cover or a more specific question that you might have that I can answer for you. So what is probate? Probate is basically where people end up when they don't have proper estate planning. So what that means is when people are alive, they either sometimes create a will or have some sort of what they call a testament in place so that the day that they pass, their family, their friends, whoever their heirs are, it's their beneficiaries who they designate to basically get control of their property, their assets, whatever it could be that they have left behind. As it pertains to you all, I believe what you're most interested in is obviously the real estate aspect of it and the real estate within the probate cases. But I think it's important for personal knowledge really quickly to let you know that people who die without a will go to probate. People who die with a will go to probate. Everybody that has a will and does not have a will ends up in probate unless they set up what is called a trust, which is a new form or a very popular form of estate planning now where basically you avoid the probate process if it's done correctly. Why avoid probate? Nobody wants to be in probate. First of all, a lot of the times when you end up in probate, you are in a situation where you just lost a loved one or somebody that's very close to you. And not only are you grieving that loss and dealing with a lot of just administrative things that you have to do in that time, sometimes you have to set up funeral arrangements, make decisions on behalf of that person to how to do their celebration of life or whatever it is that they decide to do or you decide to do on their behalf. But then you have to hire an attorney. Once you hire the attorney, don't think that it's a quick process. Don't think that you can, go to an attorney today and have a property on the market next week. It's a process that's long a lot of the times. It's drawn out. And unfortunately, it will delay the process of being able to sell or otherwise dispose of a property that the decedent, which is what we call the person who passed away, leaves behind. In this case, for example, if you have a person who passed away, whether it be a family member, a listing, or a family member calls you that they have someone that passed away and that they want you to list the property, there's a few questions that you as realtors should be prepared to ask in order to be better informed as to what the scenario is, right? So anytime that you speak to a probate attorney, whether you do so directly to get information for your client or to be able to slightly just give your client a big picture of where they're headed, you should always have your client speak to an attorney, but I would like to educate you guys on the process so that you guys can educate your client on what to expect. Not to give them legal advice, not to tell them what they're gonna have to do with the property, but only so that when you meet with a client, they see that you're informed, that you're educated, and that you know what's going on, because obviously that makes you look more polished, more professional, and more on the ball. So a few of the questions that you need to ask. In Florida, there are two types of probate administrations. There's one called a summary administration, and there's another one called a formal administration. A little trick that I tell my realtors is that the summary administration is the speedy version of the probate. They both start with S, summary and speedy. And the formal administration is the one that takes forever. Formal, forever. Doesn't literally take forever, but it's just a way for you guys to try to remember that, or, you know, be top of mind on the proper language to use. When it comes to a summary administration, this is what a lot of times you as realtors will come up against. There's two ways in which you end up doing a summary administration for a probate case. One way is that the decedent, the person that passed away more than 2 years ago. The second way is that all the property that this person that passed away left behind is either A, homestead property, or B, all of it is valued at less than $75,000. So if somebody leaves behind a house that is their homestead property, no matter what value it had, and $75,000 worth of non-probate assets, then you can do a summary administration. If all that somebody left behind is a house, you will be doing a summary administration. If somebody leaves behind a house and $100,000, you cannot do a summary administration. The cap on that is $75,000 and homestead protection. The other scenario where you would do a formal administration, the one that I like to say takes forever, even though it doesn't actually take forever, but it does take much longer than the summary administration. It's basically when you don't qualify for a summary administration. A lot of the times it's people that, you know, have a lot of assets or have multiple properties and that they didn't necessarily correctly plan for the event that they would no longer be here, that they didn't have the proper procedures in place so that these properties would automatically transfer to heirs or beneficiaries. And basically, the reason why I say that what you will run into most often is a summary administration is because A, a lot of the times when the family members are looking to list the property as it's going through probate or before a probate has been filed, is because they can't afford it. That's the truth. That's the most common scenario that I run into, because if somebody leaves behind a property that has a mortgage on it and they have $200,000 in a bank account, a lot of the times, if the bank account was properly set up to have a beneficiary, the beneficiary could easily pay off the property. You know, normally when you have a summary administration, it's because there's trouble making payments. There's trouble keeping the house afloat. There's trouble renting the house out to tenants, whatever the case may be. Also, you know, I don't know that you can legally rent out the house to tenants if the house is in the name of somebody who passed away and you don't have it rented at the time that the person passes away. Can you actually find
I actually have a question for you, right? I have seen a lot. Most of the times they will try to list that property before going into the probate process, right? So one, it's illegal because they're not supposed to be signing any listing agreements, correct?
Correct.
And, you know, and they say, well, they've passed away, and will give a death certificate to the listing agent, and the agents have not been properly trained by their office, that just because they have a death certificate, it is not okay to grab onto this listing, right?
That's correct. And
So
that's a huge misconception that I run into often. A lot of times I have a realtor come to me with a listing agreement that has been signed by someone who is obviously not the owner of record.
yes.
And tells me like, hey, I need to run this through the probate process. Here's the client. And, you know, I try to help them out. I understand what's going on. I understand that everybody needs to get their business done and whatnot. But honestly, that's not the right way to do it. Technically, the court has to designate a personal representative or somebody to represent the estate for that person to have legal authority to make decisions on behalf of the estate.
So you guys understand what she just said. It is not up to, you know, the son, the daughter, the cousin, or the sister, brother, whoever it may be, to say, hey, you know what, they passed away, I'm the next of kin. What Claudia just said is the actual court will designate the person to handle that estate. So they can't just say, hey, Guillermo or Lina, can you go ahead and just handle this for me? I'm the next of kin, this is the way it's gonna work. What Claudia's saying is, no, the court has to designate that person.
Correct. For it to be a completely legal transaction from beginning to end, you know, I would recommend that you get involved at the point where there's some sort of authority with who you're working with. And here's a downside to that as well. A lot of times I have people call my office and they tell me, hey, I'm talking to so-and-so who's the daughter. She wants to list the property. Her mom passed away. The dad passed away years ago, so the mom was the only one on title. And then the next question I ask them is, how many other heirs are there? Oh, I think there's a sister in Central Florida and there's a brother that lives out of state. So how do you know that the sister knows that the other sister and the brother that you think that lives out of state are all in agreement with the fact that this property is going to be sold? On top of the fact that, did you ask, is there a will? Maybe this heir doesn't know that there's a will, but there's another heir somewhere who has a copy of the will, you know? Another thing that happens in estate planning is sometimes people don't want to give their heirs a copy of the will. They don't want the heirs to know what they're going to get when that person is no longer there. They have the attorney hold the will, or they have a third party that's not necessarily the heir hold a copy of the will. And so then you can't just assume that because A, they tell you there's no will, there's actually no will. B, that because they're telling you that the heirs all agree, that they do actually all agree. And C, that because they tell you that that's their mom, that you're going to go ahead and get the listing agreement. I mean, unless they're showing you a birth certificate with the mom's name on it, you still don't even know if that's really the person's heir, cousin, sister, brother, grandchild, whatever they're telling you. So who are you dealing with at the end of the day? You don't even know. One thing I always tell my realtors is you have to protect your licenses, right? The same way that me as an attorney, I protect my license and I do things the way that, you know, they're supposed to be done. I recommend that you always do things the best way possible as well. I understand that there is no such thing as perfection, but I think that you should keep in mind that A, you could be wasting your time. B, you could be dealing with someone who is not even going to be able to sell the property, list the property, make the decisions on behalf of the decedent, the person who passed away. And C, you don't want to risk for a listing, an action against your license, right? Because you don't only live off of one listing. That listing, unless you're going to become a millionaire and be able to live for the rest of your life off of that listing, you need your license to be able to continue doing both listings and representing buyers and doing what you do with your real estate license. So keep that in mind that, you know, unfortunately, it's a little bit tougher than a regular deal when you deal with a probate case, but you should be prepared for that, and you should also prepare your client for that, right? Let's switch it over not only as a listing agent, but as a buyer's agent. If you represent a buyer and you go see a property and the property is in probate and the selling agent discloses that to you, or the listing agent discloses that to you, you need to also educate your buyer. This is not going to be a 30-day closing. This is not going to be a $20,000 purchase because the seller just doesn't care and just needs $20,000. A lot of times, if the property is still going through the probate process in court while it's actually being listed and sold, once you have a contract, the contract has to be shown to the court and the court has to approve the sale of the property. So one of the biggest misconceptions that I see when it comes to probate properties is that people think it's a perfect investment option. They're going to give me, you know, they're going to take 5 cents on the dollar because they just want to get rid of the property. And so this is going to be my fix and flip. if the property has already gone through the probate process, and if the property is now in the hands of the heir, titled in the name of the heir, and the heir can do whatever they want with the property, yes, you might be looking at a good fix and flip investment property, whatever you think, or a good deal for your client if it's not for you. But if the property is still going through the probate process, meaning that the administration of the probate is not complete, don't think that you're here getting like the bargain of a lifetime. That's just not how it's going to work, because the court is going to ask for comps. The court is going to see what the condition of the property will be. Sometimes the court may even ask for an appraisal if there's like a huge argument as to the value of the property, you know? And so as attorneys, we have to represent to the court that this contract that we're offering the court to accept or to approve for the sale of a property is somewhere in line with the comps, even if it's like at a small discount. But I can't go to in front of a judge on behalf of a client or an estate and say, hey, Your Honor, I'm asking you to please approve this contract for a property that the comps are at $200,000 for you to sell it for $100,000. The judge is going to look at me like, are you crazy? The judge has a duty to the heirs, and I have a duty to the heirs to get them the value out of that property. I need to make sure that they're going to, the only asset they have, or a lot of the time, so the only asset they have is this homestead property. And so I need to make sure that the heirs are going to get their money's worth. You know, that's not to say that I'm going to list it at a price, or I'm going to recommend that you list it or get a contract at a price that it's, you know, ridiculously expensive. But, you know, you need to make sure that you're going to be able to, hold on, sorry, I just saw that I got a message here. You're going to need to make sure that you're going to be able to get past the gatekeeper, is what I tell my clients. And the gatekeeper is the judge. And they're going to make sure that, you know, the property or the heirs get somewhere in the ballpark of what the actual property value is. A lot of times those properties are old or are worn down or are not well maintained. And those are all things that can be brought up to the court. And, you know, you can show that, you know, there's a reduction in price based off the need for repairs and whatnot. But at the end of the day, that doesn't necessarily mean that you're going to, you know, get a huge bargain on a probate property.
I have seen that a lot in the court. I've seen where they go back and forth with the comps and what the price should actually be. Even after they've received an offer, they actually have to show what the comps are in order to be able to get that offer signed. So I have seen that a lot with my agents.
And even when you list it for $200,000, if you get a contract for full asking price, cash deal, zero inspection, it's going to be done. The court's not going to be like, yeah, for sure, let's go. They're going to be like, why did you list it at 200 when the comps are, I don't know, 240, 250? Yes. And that's where the back and forth starts. So it's not this like wild, wild west unregulated area of law, like maybe some of the less experienced investors or less experienced realtors think. And sometimes they show these properties to their clients, like, you know, telling their client, oh, you can get this for a huge bargain. This is the type of property that you want. Don't get me wrong. A lot of times those properties are fixer-uppers and you can make some money off them if you're looking to invest or represent an investor. But that doesn't necessarily mean that you're going to get it for like $9.99. So, I have a, sorry,
yeah,
go ahead.
I was actually going to say the same thing. We have a question from Andres that says, Claudia, how does it work when property belongs to an LLC and one of the partners pass away?
So it's a complex question. Why? This is similar to a probate. You should have some sort of a business succession plan when you have an LLC and you have more than one partner. But if not, this is going to get tied into the mix of the probate and their interest and how their interest is supposed to be, you know, dispersed if the family gets it. Sometimes the operating agreement can say, like, in the event of the death of one of the partners, like their equity gets split however in this way or whatever the case may be. That's why I tell a lot of my investors that when you have an LLC and it's not a single member LLC, then you should definitely talk to somebody to make sure that you have the proper documents in place. A lot of times people think that when you go to sunbiz.com, you open it and you follow the form operating agreement that it creates for you there, that you're good, and you're good to do business for right now. But there's a lot of issues that come up during the time that you have that partnership, that you own the property, that you pay expenses, that can all be taken care of from the beginning. And when everybody is level-headed and there is no friction between the partners, it's a lot worse to be able, or to have to handle one of those situations when either there's been some sort of, you know, disagreement between the partners, or you run into financial issues and now everybody's out for themselves instead of, that spirit of camaraderie and teamwork that you had when you started the LLC. So you will look to the operating agreement to see if there happens to be a clause in the operating agreement saying what would happen in the event of the death of one of the partners. And if that doesn't tell you anything, then you're going to end up in the probate world or figuring out if there's a will and whatnot. It's complex. It's the same thing, but it can be avoided if there's a proper business succession plan in place, or if there's like a designated family member that's going to take over the business. But again, that's all stuff that has to be done before the person passes away. Once the person passes away, you're kind of just stuck in the limbo.
Did that answer it, Andres?
Yes, thank you very much. It's very clear, and I think I need a consultation with Claudia soon.
Okay, I'll wait for your call. Let's talk a little bit more about a formal administration. Although it's a lot less common, it does still happen. You may still come across maybe on a high net worth property where, you know, there are assets and there are different ways to possibly pay down a mortgage or something of that sort. But unfortunately, the property is either so expensive or the mortgage is so high that there's money, but not enough money. The problem with a formal administration as it relates to you as a realtor, you have to file a notice of creditors. When you file a notice of creditors, you have to give everybody that decedent owed money to a notice that you're filing this, you know, the probate action, and that there's money basically. And everyone has a certain time period to file a claim. When they file a claim, what ends up happening is then the court will basically determine whether the claims are valid, depending on when they were filed and how long, you know, ago the debt was acquired, because statute of limitations, like I said earlier, does not allow for the recovery of certain debts after a certain amount of time. But when you do a summary administration, a formal administration, you have to tell your clients that they have to be willing to be waiting this out more than 3 months, if not longer. A lot of times, when it's a formal administration, again, there probably is not a will, but if there is a will, you still end up in probate. A lot of times people think that because they drafted a will or they have, you know, a last will and testament, that they're going to avoid the probate process. And unfortunately, that's not the case. You go to probate court to tell the court, this person passed away, and one of two things: they had a will or they did not have a will. If they had a will, then what you're asking the court to do is to basically confirm that the will is valid. Did the will follow the formalities required in the Florida statutes? Did it have, you know, the proper witnesses? Was the person, you know, in the presence of the witnesses at the time that the actual will was signed? Was there any subsequent will? Was the will a codicil, or was it, you know, a completely new will? There's a lot of different questions of technicality that come into play. So don't think that because your decedent left a will behind, that means that the process will be, or that you will avoid probate. Don't think that because there is a will, you will avoid probate. You will not avoid probate. Chances are your probate process will be smoother, unless somebody comes out of the woodworks and tries to contest the will, say that the person was not of sound mind at the time that they actually signed the will, that the formalities required in Florida statutes were not met at the time that the will was executed. But at the end of the day, you know, you still have to go through the probate process. You're still going to have to file. And that's another thing that a lot of times the heirs don't realize. To file a probate action is expensive. The filing fee is close to $500 by the time you pay filing fee and initial cost of the summons and service, and just to start, just to get your foot in the door. Then you have to pay somebody to prepare your petition, to do the rest of the process for you. So another issue you run into a lot of the times is that your heirs don't have money to pay an attorney to do the probate. And, you know, some probate attorneys, depending on, you know, the administration, whether it's a formal or a summary, if it's a formal administration, some probate attorneys don't charge the entire amount or only charge a small amount up front and then take a percentage of the entire estate that was administrated. But imagine if you're doing a formal administration, that means that you probably have property, and you definitely have over 100 or over $75,000. So if you're paying a percentage, you're looking at a couple to a few $1,000s to administer a probate. And so another thing that you need to be aware of is, another question that you as a realtor need to ask, whether you're a buyer or a seller, is there a mortgage on this property? Because if you're looking at a property that's upside down, I mean, if there's no money, that the heirs are not going to get any money from the property whatsoever. And at the end of the day, you know, there's no money to pay for the probate, and there's, you know, are you wasting your time again? Are you spinning your wheels? Or is the commission worth the headache? You know, if we're talking a little apartment that's worth $120,000 or $130,000, do you really want to focus your time on that task? Or do you prefer to focus your time on either another buyer or another property for that buyer, or even try to capture a different listing? I am always of the belief that no deal is too small, or no deal is, you know, like, I'm not above any deal. And I think that that's a great mentality for you to have as a realtor. But I do think that at a certain point, you have to make a decision as to whether it's worth it for you to invest your time into certain clients or certain properties or certain listings, right? So it's important to get a good picture of what's going on from the beginning. At the start of the video, I started talking about the questions that I think that you need to ask as a realtor, whether you're representing the heirs that are going to list the property, or whether you're going to represent a buyer who's interested in a property that's in probate. I recommend that you ask the following questions. When did the person pass away? Because that's going to tell you if they're over the 2 years or not over the 2 years, if it was recent. You're going to ask if a probate has already been filed. That's going to tell you if you already got the process started, or if you're starting from scratch. You're going to ask how many heirs or known heirs, because that's a whole other can of worms. I've had heirs show up at the time that we probate an estate, and it happens. So who are the heirs that you know of, or who are the heirs that you think you know of? And what are their relationships? So for example, if the mother passed away, how many children were the mother's children? Or if it was a couple, you know, if it was a mother and father that passed away either simultaneously in car accidents, it happens. Were any heirs not of both parents? So for example, if both parents died simultaneously for any reason, did any heirs that were the mother's heirs, are there any heirs that are not the father's heirs, but they are the mother's heirs? So a situation where it's like the same mom, but a different dad. Another question to ask is this the only property, real estate, the only real estate that the person left behind? Yes or no? If it is, was it their homestead property? Because believe it or not, I have decedents that pass away and they have property, but it's not their homestead property because it's an investment property. You want to know if the property has a mortgage. If there's a mortgage on the property, what is the balance? Have you gotten the mortgage statement lately? Do you have any idea? Because technically, as an heir, you cannot call the mortgage company and give your mom's name and your mom's social security number. I don't know that I've ever seen it happen myself, but you're not supposed to do that, right? So we're not supposed to have that information, or we wouldn't have access to that information unless we had a mortgage statement. Now, there is a way to legally do that. You call a mortgage company, you tell them the person passed away, they ask you for a copy of the death certificate, they ask you for a copy of the ID of like the heir that whoever you're claiming is the heir. If there's a probate that's already been filed, the mortgage company will ask you for a copy of the order assigning this heir as a personal representative of the estate, so that they know that they actually have authority, which is the same thing we just talked about earlier, to actually represent the estate, or to, you know, make decisions or get information about the mortgage. And after that, then you'll know or have a better idea of what the equity could be, right? You obviously need to look at the property. Like I said, you know, looking at the MLS is always not a good thing to rely on, because a lot of these properties, like we discussed earlier, need a little bit of TLC, and you should either have a very clear conversation with the listing agent if you're representing a buyer, or as a listing agent, you should physically go to the property. Like, don't have a listing appointment at the heir's house and just sign them up. Go look at the property, make sure that you know what you're getting into. Is this a property that's going to be a cash only because it's so bad, or is this something that could possibly still be financed? And another conversation to have with the heirs is, do we have money to put some money into the house to make certain renovations, even if it's minor, to get maximum value for your listing? It's similar to the conversations that you would have with any other with any other client, but just a little bit more in depth, right? Because like I said, you need to get a big picture to know exactly where you stand, and to be able to then, as a listing agent, properly inform your buyer or the buyer's agent of how the situation is going to be, if they need to be expecting a 90-day closing, if they're okay with a 90-day closing, whether you for sure pretty much know that this is going to be a cash deal, or you might have to go get an inspection on the property, or have your seller do a pre-listing inspection to be able to see exactly what's wrong in the property, to not have any surprises after you're under contract. So those are the kind of questions that you need to ask, and then one question I always ask, which is obviously very subjective, because depending who's on the phone, you'll get a different answer. But then the next question I ask is everybody here in agreement on what we're doing with the property, right? Sometimes you have heirs who say, I don't want to agree to list the property. I think that we should keep it. We should make it an investment property that we're all four going to manage, and we're going to split the profit, or whatever the case may be. And other times you have people who say, yeah, we can't afford it. We don't want the headache of having to rent it, manage it, or anything like that. And we just want to go ahead and get rid of it. Awesome. But then sometimes you file a probate representing that everybody wants to sell the house. You serve everybody. And then when people get served, they're like, wait, I don't want to sell the house. So you're spinning your wheels, right? So it goes back to asking the questions that are going to make the process the most efficient for you, so that you have a clear picture of what exactly is going on, and that you better know how to guide your client, how to handle the transaction, and how to professionally be able to,
Claudia, we have a question. It says, hi, Claudia, question. Foreign sellers on the deed X and Z has husband and wife. Husband passed away in Italy. Can we take the listing with the signature of the wife and death certificate? There's a vacation property, not investment. Do we need to wait until the estate tax return is filed to sell the property?
So that's another good question. A lot of times people assume that the deed is written as tenants in common, joint tenants with right of survivorship. That's very important. Look at the deed. If you don't know how to read the deed, Andreina, we should definitely do a class on that, if that's not something that you already have done. But small changes in the wording of the deed tell you whether when one person passes away, it automatically transfers to the other person, or whether when one person passes away, you still need to probate the other half of the property, the other 25% or whatever percent interest it is that the person who passed away had. In this case, if the deed specifically says that they are husband and wife at the time that the deed was signed, because the fact that they were husband and wife at the time that they died does not mean that they bought the property when they were married. That's the big difference. If the deed says they are husband and wife, then they are joint tenants with right of survivorship. So if the husband passed away in Italy, then the wife, with recording of the death certificate, should be able to continue doing whatever it is that she wants with the property. There would be no estate tax returns as to it relates to this property. That is my understanding, but I am an attorney, not an accountant, because that property is not probate. It's not a probate asset. It's a non-probate asset because it transfers automatically only to the wife at the death of the husband. If there is a probate, it would not include this property. Did that answer your question, Tony? Okay, Tony, send us a message if anything, if we need to clarify.
I'm gonna unmute Tony. I just unmuted you. Does that answer your question?
Yes, it does perfectly. Thank you very much.
Okay, no problem. That leads me into something else, right? And this one is more maybe for a little bit of a personal aspect to it, and not just you as a professional, but you as a human. You would be surprised the number of times that I have people come to me to file a probate action because their decedent family member or whoever did not have beneficiaries on their bank accounts, 401ks, life insurance, whatever. It's ridiculous. It's crazy. Every bank account, every 401k, every life insurance should have a beneficiary, and some of them have second beneficiaries. So that if the first beneficiary, for whatever reason, is not available, died before you, whatever, there's a second beneficiary that you can still avoid probate with. That doesn't necessarily happen with real estate, but I'm going to come back to that. There is a way to make that happen with real estate, and that's something else that you should know. And Andreina, something else that we could possibly discuss in a deed class or a deed Zoom like this. Yes. If you have a bank account, a savings account, a 401k, whatever, checking, any account, call your banks. It's a 5-minute phone call. I want to verify that I have beneficiaries on the account. Can you verify that for me? Yes or no? If you don't have a beneficiary, you end up in probate. But if you have a beneficiary, guess what? Nothing happens. You pass away. The next person basically sends them a copy of the death certificate and gets their money. That's it. But another huge issue is people pass away. They have their beneficiaries listed on their account, but people don't know where they have their accounts. So sometimes I have people come to my office and tell me, I know he had a 401k, I know he had a life insurance policy, but I have no idea where the 401k is, where the life insurance policy is with. And those are very simple things that we can all avoid as human beings. If we have any accounts, make sure they have beneficiaries. If you can add a second beneficiary, please make that a priority, so that if God forbid something happens to your first beneficiary, you're still going to get to avoid probate through the second beneficiary. And also make sure that if you do have a 401k, a life insurance account, whatever, like I explained earlier, you don't have to tell your heirs, hey, we have $7 million for you the day that I die, but you can make sure that there's somebody in the family that knows, hey, look, he had a checking account at Bank of America, he had a 401k with, I don't know, McDonald's, and, you know, so that when you pass away, your beneficiaries can quickly and efficiently identify what assets you had and be able to go from there. What I mentioned briefly before about a similar beneficiary to a deed is a ladybird deed, an enhanced life estate.
I am such a fan of the ladybird deeds. I mean, I've been telling my parents to do this for my sister and I for the last 7 years, ever since I found out what ladybird deed entailed. And right now, I want to say, I mean, a lot of people don't know about, you know, obviously my personal stuff, but my aunt, I became legally responsible for my aunt with Alzheimer's last May. And so I had to do a trust for her, write a will. I mean, I was able to handle all that for her. And at that moment was when my parents were like, all right, fine, we'll do the ladybird deeds on the property so that you and your sister don't have to go through all this hassle you just went through for your aunt.
And unfortunately, Andreina, a lot of people hear about this topic. They know about this topic. They know that we tell them that it's a terrible situation. But it's so unfortunate that every time that I have somebody that comes to my office and they tell me, I knew about this, but I never did it because I didn't realize how much of a nightmare it really is.
So for a lot of the agents that are here that are listening to us talk about ladybird deeds, this is that you're going to be putting your children on the deed of the property, but they cannot do anything. They have no authorization to sell, to rent, to do absolutely anything with that property until the actual people on the title pass away.
Right. And so
automatically go into the deed once they do pass away.
Correct. One of the things my office does is real estate closings. And every single time I have a real estate closing, I inform the buyers of what a ladybird deed is, ask them if they would be interested in leaving an interest to someone. It doesn't even have to be a child. It can be a son, sister, cousin, grandfather, parent. Sometimes when it's an unmarried couple and they're not both on title for any reason, they leave it to the other spouse. Sometimes the parents leave it to the children leave it to the siblings. It can be anyone. It doesn't have to be, there has to be no relationship. It's just a matter of you putting somebody on there. And we asked.
Hold on, I'm sorry. It says, good morning, Claudia. If you have a mortgage, can I guess it's.
Yeah, we started talking about it right when Nancy asked that, but she was asking basically, can you get a ladybird deed if you already have a mortgage? I'll come to that right now.
And then Marie is asking, what's the name of the deed? It's called Lady Bird Deed. No.
It's written correctly in Nancy's message. If everyone can see it, I'll type it here again. And then that is like the common name, what everybody calls it, but the legal name is, it's called an enhanced, sorry, I'm typing and talking at the same time. Enhanced life estate is the name of the interest. And to clarify what Andreina said, or to further her point, it's a future interest. What does that mean? The fact that it is currently on your deed means absolutely nothing unless the people that are on title right this second both pass away. If there's more than one person, or if there's only one person, that person passes away. And all it does is it automatically transfers. Again, you record a death certificate. If you can record a death certificate, you automatically transfer that property to whoever is the future interest. So to give you a more clear example, if I own a property and I'm the only person on title, and I have a future interest to my sister, that promise to my sister that she's going to get title of my property when I pass away means nothing to my sister as long as I'm alive. She can't tell me I can't sell. She can't tell me I can't refinance. She can't tell me I can't mortgage. She can't tell me I can't paint my house. She can't tell me who I give my house away to. She can't tell me if I have tenants or if I don't. She cannot do anything. It is expensive toilet paper for the person that has the future interest, in that example, my sister. If during my lifetime, I get in a fight with my sister passes away before me, my sister acquires a huge inheritance from somebody else, and I decide she doesn't need that future interest anymore, at any time, me, as the only owner of that property, I can go in and change it. I'll change it back. I'll get rid of her. I'll remove her. I'll tell her, bye, you don't need that anymore, or I'm not going to give it to you anymore. I got married and I want to put my husband, or I had children and I want to put my child on there. You can change it however many times you want.
Yeah.
You can change it to whoever you want as long as you are alive. Once you're not alive, whoever you have in that designation of future interest, in my example, my sister records the death certificate of my death, and then she shows up with a deed to my property. Not literally, she doesn't literally get a deed to the property, but by recording the death certificate legally, the title automatically passes to her, because that is what the deed says. The deed will say, the interest is mine as long as I live, and then any remainder after my life goes to XYZ. I ask everyone that does a closing with me if they want to do that, if they're a buyer. After they tell me that they're interested, the next thing I do is I run it by the lender. I have not received resistance on that from any lender. So I don't want to say every single lender on the planet allows it, but I have never come across a situation where the lenders had said no way, because again, it's expensive toilet paper. It's a future interest. When you're dead, the property comes to you. They can still foreclose if you stop paying. They're still protected in every single way by the instruments that were signed at closing at the time of purchase. And I've never received any, resistance, but I always run it by the lender, because I want to make sure that there's not going to be any issues. And now let's circle back to Nancy's question. Nancy asked, basically, can you do it if you have a mortgage right now? Again, the future interest, that promise that you write on the deed to give the property to XYZ, is expensive toilet paper. It means nothing right now. So 99% of the time, the lender doesn't care, because you are still on title, you are still responsible, they still have a mortgage, you haven't necessarily changed the present interest of the property. Correct. That being said, if you know anything about mortgages, they all have an acceleration clause, and the last thing you want is to accelerate your mortgage as a result of improperly doing a ladybird deed if a qualified individual does not do it for you. I know notaries do them. I do not recommend that you ever do that with a notary. A simple difference in language of 2 words can change the complete meaning of the deed, can completely change your intention, and can completely change title. And you'll see yourself in a terrible situation when your mortgage tells you you owe them the entire balance of your mortgage next month. And B, I never want to put my client in a situation where I did a ladybird deed, because I know legally it doesn't mean anything until you actually pass away. So I assume that your mortgage is going to be okay with it, and then you get a letter asking for the entire balance of your mortgage next month. I always run it by the lender. I do not let the client do that. I have the client give me authorization to speak with the lender directly, be very clear with exactly what's going on, get permission in writing, And after the permission has been authorized in writing by the lender, I go ahead and I do the ladybird deed for them.
Yeah. I actually, and just to say how important this is, right? So my case with my aunt started that my aunt was living in her ex-mother-in-law's apartment that her ex-mother-in-law had been living with. They've been living together for 10 years. Her mother-in-law falls at 90 years old, right? And she was placed in a home. And there's a life estate place that once, the mother-in-law passes away, this apartment goes to 3 people, right? But the mother-in-law has not passed away. Now my aunt has Alzheimer's, and I have to grab her and put her in a home. And in order to protect my aunt's daughter, her portion of who this money is supposed to really go to, I had to build a trust based on her third portion of that property. I mean, it's insane, but I mean, from my entire experience of everything that I had to go down through that, I say protect yourselves, protect your loved ones, because you really never know what's going to happen. And it's just better to have everything in place in the way that you want it to be in place than later on have everybody else kind of like, oh, but I don't want to sell it. Oh, but I deserve more. Oh, but why are you selling it? Why are you talking to the realtor? Just kind of like have everything in place so that there's no issues later on. Because everybody is, when somebody passes away, it's in an emotional state. We're not thinking clearly. Decisions are being made out of emotional, out of an emotional place.
Impulsive, yeah.
Yeah, it's very impulsive. It's not carefully thought out. So, I say just have everything in place correctly before you get there.
Correct. I agree with you. And I tell this to my divorce clients.
Yes.
They usually come to my office, or sometimes they're like, yeah, we have an agreement. I'm like, put it in writing right now before one of you gets emotional about it. It's
Yes.
normal to get emotional. It's not a negative thing. They're normal life processes and normal reactions to these life changes. But, sometimes it's better to get these things done when you have a level head. A lot of times, and sometimes people don't have good relationships with their entire family. It's sad, but it's true, and it happens. And that doesn't mean that we're bad people or that they're bad people. But if you're not preparing a will, or you don't have any sort of estate planning to either disinherit someone, you might end up giving a portion of what you thought your other children or other family members were getting to a family member that you don't want to receive anything. Sometimes, you're not okay with, if you pass away without a will, certain people in your family will all get a certain percentage. If you have kids, it'll be split evenly as long as you don't have a spouse. And there's certain rules where the state will determine what happens with your property if you don't do that for yourself. Sometimes people don't want their kids to be the ones to get it. They want their grandkids to be the ones to get it. And those are all decisions that are good to make while you can make them. Or if you have a certain family member that you think is more responsible, more level-headed, handles stress and emotional situations better, and you want them to be the ones that are making the decision. You don't want the court to decide that because you lived with this daughter is the one that's going to make the decisions for you, when maybe in reality the fact that you lived with this daughter meant that she didn't make the best decisions for herself. And different things like that. You would always want to have control of that situation. So it's best to have it written and agreed upon and decided. You don't need anybody's input. You only need your input. And you can make those decisions ahead of time. The same way, like I said earlier, you should make those decisions for your business ahead of time, not only when it comes to you passing away, but certain aspects of your business, of what if you would want to answer those questions while everybody is cool, calm, collected, so that you can make the best decisions, the most rational decisions, the most thought out decisions. And that's, basically what estate planning is. And like Andreina said, there's even a way to avoid probate, which is doing a trust. It's a way more advanced version, let's call it, of estate planning. It's gotten a lot more popular now as people have become more educated on the probate process and how terrible it really is. And don't get me wrong, it's a great process to be able to administer these estates when the people themselves did not take the time or go through, the process to decide what's going to happen with their, property or assets when they're no longer around. But it's just a terrible situation for the family. And that's really what estate planning is. It's not about you, it's about everyone else. And it's about what you leave behind for everyone, not in monetary or assets, but in, you know, peace of mind, in knowing that your assets are going to a certain place the way that you designated it, and that your family is going to have an easier time getting through the probate process and not having to fill in the gaps and make all the decisions for you. Tony has, go ahead.
Like feeling it back as a realtor, do you imagine getting that listing before the probate has begun and then finding out that there's two other siblings who might already have another realtor with another listing agreement for something that they're not even entitled for? You know what I mean?
Who may have even spoken to another attorney to start the process and you haven't been served yet. So, you know, it's a very important situation. And if you are speaking to the family members, one of the tips that I would give you is try to get all the heirs together in the same room on a conference call. Do a Zoom,
Yeah.
you know, like something, because at least that way,
way of life is Zoom, you know?
yeah, that way you have everybody's version right there. You're not getting one side of the three parts of the story.
Yes. Now back to Tony.
Yes. Okay. So he said this particular client is 90 years old. Her CPA advised to file an estate tax return for her deceased husband, meaning paying the IRS about $40K. If we complete the sale of the property and she has more interest in the U.S., is it possible for the buyer, the new owner, to get a lien on the property in the future until the estate tax is paid? So it sounds to me, Tony, like what you're talking about is something similar to a FERPTA issue, because you did mention earlier that they were not, they're foreign sellers. I'm not an accountant, so I'm going to be very careful about answering the estate tax return. I said earlier, and I will stand by what I said, that there should not be an estate tax return if the property automatically transfers, if the deed says they are joint tenants with right of survivorship. If they're not, that could completely change my opinion. But based off what you explained, and assuming that the deed said they were husband and wife at the time that they purchased the property would automatically transfer to the wife. And then the wife then at the time of the sale would have to hire an attorney, not an attorney, I'm sorry. You would have to hire an accountant to work with the title company to do a FERPTA withholding certificate. And then if you sell the property for less or whatever the case may be, there's different ways in which you either don't have to send anything or have to send less than what the normal withholding amount is. If you have a FERPTA question, feel free to reach out to me after. I can definitely walk you through that process and explain it a little better. But another question for you, Tony, and maybe a question for you to ask your client or the 90-year-old lady is, was this property purchased in their individual names or was it purchased in the name of an LLC? Because a lot of the times when it's a FERPTA transaction, it's not in the name of their individual names, it's in an LLC. So I think that might be the whole circling back of your question, is that I think that maybe they don't own it as joint tenants with right of survivorship. They owned it as an LLC to be able to purchase as foreign buyers. And as a result, then it doesn't automatically transfer.
Correct. Clarissa's asking, hi, Claudia, what type of documentation should we request from a trustee of a property of a deceased person in order to properly list the property?
Okay, if there is a trust, the first page of the trust usually does not contain any sensitive information, and a lot of people will usually share the first page of the trust with you as proof that this trust exists, that their parent that was on title was the first trustee of the trust itself. It usually will not contain the beneficiary section. So people, and understandably so, are cautious to share the entire trust agreement with anyone, you know, because it's a private, basically it's a will. It's similar to a will. It says what I have, where it's going, how I want it to be distributed, who's going to get it at what age and what amount. So a lot of people are very confidential when it comes to those things. They usually don't have a problem sharing it with a real estate attorney. So a lot of the times my realtors come to me and they ask their clients to send me the trust itself, the entire executed document, so that I can verify that they have authority. Another simpler way, like I said, is to ask for page 1. But like I said, page 1 may not have who the successor trustee is. And that's where you would see that they have the authority to be the listing contact for you. The other option, which I mentioned in the chat, actually, like I want to say it was like 3 or 4 weeks ago, somebody asked a similar question, is ask for a certificate of trust or certification of trust. Basically, it's an affidavit that a lot of trustees have when they are trustees of a trust that says they certify to you, basically, my name is so-and-so, I am the trustee of XYZ Trust, the trust was signed on this day by this person, I certify that I don't know that the trust was revoked, that I've been removed as trustee, that XYZ, XYZ, XYZ. Again, that is similar to like asking for page 1. It'll give you some idea, but it doesn't necessarily 100% confirm it. The only thing that will 100% confirm it is having someone review the trust and confirm for you that the trust actually says what they tell you it says. But even with that, if I don't get a certification of trust, in addition to a review of the entire trust, I still can't confirm with you that nothing has changed, because until I have a signed affidavit, the trust document could have changed and nobody told me anything and I had no reason to know or no way of knowing.
Awesome.
So Clarissa, let me know if that answers your question or if you have any additional questions regarding that.
Yes. Does anybody have any other questions? You guys are able to unmute yourselves and talk to us. Are we good?
We have a quiet bunch today.
I think we scared them off, that no one's talking.
Complicated process and the topic's a little bit convoluted.
And probate's kind of like, it's a dirty word because obviously it entails that somebody passed away, but then it's also that exotic word for that investor, like, oh wait, probate, you know what I mean?
And for you as a realtor, it's a great way to stand apart, you know, and to brand yourself possibly to be, you know, a probate specialist or to have that as one of your areas of expertise. The same way that some realtors like to be listing agents or, you know, buyer's agents. That's a way to set yourself apart and help your branding.
Yes. Any other questions? Oh, perfect.
Claudia, what are your areas of expertise? What exactly is what you practice in your firm?
So my firm does real estate. We have a title company and we are real estate attorneys. We do litigation, we do evictions, we do foreclosure defense, we do foreclosures for some lenders when they're private lenders. My ideal client is investors because I can help them not only on the purchase and the sale, but also if they have any issues on title, we do quiet title actions. But my firm also, what I'm trying to actually make my niche within the firm is small business owners, which is why investors are my ideal client, because I can help them on the business side, make sure that they have the business succession plans when they run into issues with contracts or anything like that. I can help them with that again. But we also do family law and we also do estate planning. So I'll explain to you the reason why this all makes sense, even though it sounds like we're all over the place. It's actually very focused and it's a very succinct practice area. I'll tell you why. The way we get the majority of our cases, believe it or not, are divorces. And so the divorces come to our office. We do the divorce. We do them contested and uncontested, with children, without children, whatever it is that you need. We also do prenups and postnups. And so then when we get a divorce client, the divorce clients nowadays usually have a property and a small business. And a lot of the times you need to divide the small business, if they don't have a prenup according to law, whatever it is that, or whatever the parties agree to, somebody needs to keep it, somebody needs to keep the profits. If somebody made money and there's value, then you have to distribute that. And then there's usually a property. And a lot of the times, unfortunately, but it's true in society today, buyers are buying properties depending on two incomes. And when you reach the point where you have to face a divorce, your income is halved or somehow reduced in some way a lot of the time. And so that's where we end up, obtaining listings for our agents or helping our agents connect with possible listings. And then from that, we also do the real estate closings here in the office. And then the estate planning just ties in very well for all of that. You know, one of the things that we run across very often is when you have a will and you get a divorce, you have to go back and change your will. Because if not, guess what? Your ex-wife, ex-husband is gonna get a lot of money. And that's probably not what you want after a divorce, you know, unless you're doing it on behalf of a minor child or something like that. So basically all of the practice areas intertwine fine. But my ideal client are investors because, like I said, they touch various of the practice areas that I do. But I'm very heavily involved in real estate. I've been in the real estate world for 7 years now. I started off as a title processor. I eventually went to law school, and now, I'm part of a firm where we do a lot of real estate. But our office is very versatile, and that's what I think is the value that we provide, is that we can help you with a lot of collateral issues that come up with real estate. We do partition actions. That's been super popular lately. So, to answer it, we do a few different things, but as briefly as I can do it, it's family law, real estate, business law, and estate planning.
Very nice. We had two questions here. One says, can you briefly go over the pros and cons of land trust? And
Christian, that's a super complex topic, but I'll tell you sorry.
I think that maybe do like a very quick thing because
Yeah.
it's already 11, but I think that might be something that you guys can talk over.
Yes, definitely. I'm in the chat. If anybody wants to reach me, just look for my name. I'll also share my business card in there if it's okay with Andreina, or just reach out to me and I'll message you privately. I usually reply privately whenever somebody asks a question if I don't think it'll benefit the entire group. But land trust, the only issue with that is a lot of times it's super difficult to finance. That's the one big con. A pro is like you're anonymous as anonymous can get, but that is why it's so difficult to finance. Reach out to me and we'll talk a little bit more about that, but it's a complex way that people do estate planning and try to avoid, being under, or not avoid, they try to be under the radar using that. Marina also asked, what happens to a life estate property where the wife is not listed on the deed and the husband passed away? Let's say the parents and husband passed away. Marina, I need you to clarify your question a little bit for me.
Can you unmute yourself, Marina, and ask this question? I'm gonna unmute you. Talk to us, Marina.
Okay. Hi. The life estate is on the husband's name, and if she's not on the deed and the beneficiary was the husband, but he passes away too, what would happen to that property?
That's
Nothing.
not the wife's.
Yeah. If I understand correctly, it's a property where the parents of the husband own the property and they leave a life estate to the husband, but the husband is the only one that's listed and not the wife.
Exactly.
So by operation of law, when both of the parents for the husband pass away, the property would go to the husband. And when the husband has title, so assuming the husband outlived his parents, then you would have to probate that interest.
Okay.
The title would just stay in the name of the husband unless the husband does something after the fact. And guys, that's another pointer for everybody to keep in mind. If you have a life estate or an enhanced ladybird deed, to use the same, sorry, not an enhanced, I mixed up the two. If you have a ladybird deed or an enhanced life estate, they're the same thing, two different ways of saying the same thing, and you obtain an interest in a property, you need to do another ladybird deed now, because now you are the beneficiary and there's no more beneficiary. So you need to record the death certificate, and then you need to talk to a real estate attorney that's going to properly change it so that now you that are the title, the person on title, have a beneficiary in case anything unfortunately happens.
Okay.
Yes.
Okay. Thank you.
No problem.
Thank
now,
you.
Catalina is asking about your company contact phone number. Do you want, I want you to say it, and then I want you to type it into the chat so that everybody can hear it, and then also be able to have it there on the chat just in case they miss what you say.
Okay, I give everybody my cell phone.
Beautiful.
You can call me whenever you want, but I'm not always gonna answer. Please, if I cannot answer, just leave me a voicemail or send me a text message. Sometimes I'm on a call and I can't talk, but I can text. Like right now, I'm getting text and I'm trying to answer quickly. My cell phone is 786-973-6644. I'm going to see if this lets me put my business card in the chat for the Zoom meeting. Yes, it did. I believe so. Can you just verify for me, Andreina?
Absolutely. Yep, I got it.
Okay, and then basically, if you guys need me, you have all my information. That's my cell phone. Text me, call me, send me a WhatsApp. I try to be 24/7, but I'm a human being. So sometimes I don't get back to you at like 12 a.m. Like I accidentally texted Andreina last night. But I will definitely get back to you, and I will make sure that, you know, I try to answer any questions that you have or help you or your clients in the best way possible.
Yeah, I think this was amazing. It was very, very educative at a moment that we're living right now. I thank you so much for your time, Claudia. I mean, every time I ask you, you're just, you know, very available for us, and you're always, you know, want to help and chime in, and you're a big asset to the group chat. So thank you again for today. Thank you again for being part of this crazy group. And you know, let's continue growing everybody together.
Yes, guys, we can do it. Forget what's going on. Keep your routines. Keep at it. You know, this is only going to be a little bit. I'm still getting closing files. I'm still seeing listings. I'm still seeing contracts. You guys just keep at it. You're going to keep doing great.
Yes, I want, before we leave, because this is our weekly mastermind, right? Before we leave, I do want to leave with a train of thought of, I always say this, whatever you guys work on today, you might not see the results of that for 3 months. So if you guys are at home thinking this vacation or panic mode, or, you know, I can't work because everybody else is in panic mode, in 3 months, you will be starving, right? So the biggest thing to do right now is continue to prospect, continue to do your touches with your clients or your database or your pipeline. Continue to do consistent work so that in 3 months you're not starving and you're actually, you know, receiving what you're doing today. All right, guys. So with that, let's conclude. Thank you so much, everybody, for being on this. And Claudia, again, it's an honor to have you. We're blessed. Thank you so much.
Bye, guys.
Bye, guys.